And welcome to those of you who are joining us online. Thank you for this sort of attendance that's more robust, I think, than we originally thought, but the timing on this event, we are hoping, could not be more appropriate. In 1994, Congress enacted the Freedom of Access to Clinic Entrances Act, or the FACE Act, to counter what its backers called a organized nationwide campaign of blockades, vandalism, violence, and arson, with some congressional members even calling it terrorism. While these activities are already crimes, as we know under state law, so many protesters and such excessive violent tactics, we were told, necessitated federal intervention because local law enforcement and state courts were overwhelmed. But rather than enacting a statute in such a way as to minimize the likelihood that it would be weaponized and used to suppress ordinary pro-life activity and expression, abortion advocates on Capitol Hill created a weapon for attacking and suppressing a much broader range of pro-life activity and expression, whether silent prayer, quiet worship, peaceful civil disobedience, or simple speech. And while the law itself also protects crisis pregnancy centers and houses of worship, in practice, and under the previous administration in particular, the law has been used to target and prosecute pro-life protesters by a ratio of 15 to 1. For nearly its entire tenure, the FACE Act has been a springboard for the politicized prosecution of conscientious objectors, eliciting, especially in our nation's modern history, the kind of pre-dawn gunpoint raids characteristics of those for drug kingpins. Today, we'll examine the context in which this controversial law emerged, evaluate its constitutionality, look at how federal authorities have enforced it, and review arguments for why Congress should repeal it altogether. To begin our program today, it is my great honor to welcome Congressman Chip Roy, representing the 21st Congressional District of the great state of Texas. He serves on the House Judiciary, Rules, and Budget Committee, and is the policy chair of the House Freedom Caucus. And most germane, he has introduced the FACE Act Repeal Act of 2025 to permanently end the law that has been too long weaponized against pro-life Americans everywhere. Congressman.
Well, thank y'all. Thank you so much to the Heritage Foundation for hosting this important event. This is an important issue, and it touches on a whole lot of different facets, but it is critical that leading conservative voices like the Heritage Foundation bring issues like this to the forefront. I'm going to take a little aside here, but it's relevant. There's another issue, right, on the border and the wide open borders and all the danger that's occurred to the American people. And I don't know if you saw the night before last at the joint session, there was a woman in the balcony named Alexis Nungare. Alexis's daughter, Jocelyn, was killed last July in Houston at the hands of Tren de Aragua. And the president invited her as his guest, and named a wildlife refuge after Jocelyn in her honor. Now, I bring that up because Alexis, I've gotten to know, Jocelyn's mom. She was my guest at the State of the Union. Took her to the inaugural ball since the inauguration was all inside. She couldn't go. So we took her to one of the inauguration balls, and she's just a wonderful woman. She's 28 years old. Now, that's why it's relevant. She chose life when she was 14, and she had Jocelyn. So Alexis is only 28 right now, and lost her 13-year-old daughter last year at the hands of these violent gangs. I'm not here to talk about border security, but I am here to talk about the importance of life and the importance of the rule of law and the importance of doing things the right way, the importance of impartiality and justice, but also the absurdity of our colleagues on the other side of the aisle. Just the radical, unbelievable views for them not to be willing to stand up and applaud the fact that the president was honoring Jocelyn Nungare. They wouldn't even stand up. They wouldn't stand up for the young man that was being honored who was battling cancer, or had battled cancer and is a cancer survivor, right? Or the young man who was given acceptance into West Point. Now, why do I bring that up? Because the other side is so radical, you have to understand that and treat it that way. You have to act accordingly, in terms of what we're up against. The radical progressives that were at the Department of Justice under Merrick Garland, including Kristen Clark, were targeting pro-lifers intentionally, purposefully, and with the highest of charges by looping in conspiracy into it. They did it on purpose. Now, they were so beholden to the death cult that is their worship down at the altar of abortion that they went after a woman named Lauren Handy, who is a 31-year-old progressive activist. She's a progressive. We don't agree on anything. I've sat down and met with Lauren. We don't agree on much of anything, maybe more now. But at that moment, when I first met her, we agreed on life. And so she had the courage to stand up for her convictions in defense of life. And the radical progressives at the Department of Justice targeted her anyway. It's like, we don't care that you're one of us on 99% of the other things. You had the audacity to want to go and defend life. They can't stand it that there are people that want to get to the bottom of the DC-5. And what we all know is the murder of those young lives. I have introduced and reintroduced the FACE Act repeal legislation that I've introduced in the past. I've got my notes here only. Obviously, I'm not looking at them because I can't remember the bill numbers. H.R. 589, just so you know, H.R. 589 is the FACE Act Repeal Act. There are 32 co-sponsors. Now, I will say this, I'm deeply proud of the president and his administration for issuing their pardons for those that had been wrongly targeted and persecuted, prosecuted, convicted in various forms, depending on the individuals. Whether it's the fairly well-known individuals like Paulette Harlow, a 75-year-old grandmother, or Eva Idle, who had survived death camps in Eastern Europe to then be thrown into prosecution and disarray here in the United States for simply carrying out her pro-life views. Those are well known, but there were 24 that were pardoned because of the persecution by the Department of Justice under President Biden and Merrick Garland. I'm very proud of the administration for doing that. It's really important. But like everything that this administration is doing, the executive orders, the border security, going after all of the waste, fraud, and abuse through DOJ and identifying all of that, it's a blip in the radar screen if we don't make it permanent. Because if you don't think for a minute that the next administration that is a radical progressive Democrat in the White House or another brain-dead president with radical progressives all around him, and by the way, I got to speak truth. That's what was going on. The next time that happens, what do you think they're going to do? You think they're going to back off and suddenly be tame? Or do you think they're going to come in with a vengeance and use every single tool at their disposal to target you, to target us, to target pro-lifers, conservatives, people who are people of faith? Of course they will. This is why the FACE Act needs to be repealed. It's not enough to pardon. It's not enough that the Department of Justice under Pam Bondi or the FBI under Kash Patel will not be used and be weaponized against us or pro-lifers. That's great. That's awesome. That is a 3-year and however many days are left reprieve, right? We have to make it permanent. That is why it is appalling that Republicans have not moved the FACE Act in Congress. We have not had a vote on it in committee. We have not had a vote on it on the floor because there are people in our own Republican Party who are too afraid to touch it. The FACE Act. I'm not talking about something that might be more controversial. We're talking about literally saying we should repeal a law that has been used to the tune of 97% since its inception in 1994 of the prosecutions and the targeting of individuals under the FACE Act were for people who are pro-life. There is no blindfold on Lady Justice if that is what is occurring. And therefore, there is no belief in the rule of law and our system of justice if that is what is occurring. So where are the Republicans? Why has the Speaker not brought this to a vote? Why have we not brought this up to a vote in the House Judiciary Committee? So I'll make a little news here. If my Republican colleagues continue to refuse to bring the FACE Act up for a vote in committee or the floor, I will file a discharge petition, and I will start to try to move the bill irrespective of the normal procedures. I'm not going to sit back and wait while people hide and refuse to bring something forward because, oh no, this might be a little bit more controversial than just moving another continuing resolution. It is time that we change. It is time that we lead, and it is time that we make things permanent. The FACE Act is one of those things. There are countless others, but that's for a speech for another day. But I'm very thankful for the people here. I'm thankful for my staff. My Chief of Staff, Sabrina Hancock, is here. My comms director, where's Armani? Armani's here. My former staffer, Jonah Wendt, who's a fixture in the pro-life community and was the lead proponent of getting this drafted before he left to other pastures. But I'm deeply appreciative of all the support of people in this room, your commitment to the pro-life community, and the Heritage Foundation for being willing to host this. I appreciate it very much. God bless you all.
I'm going to introduce my panelists and have them join me on stage. Tom Jipping, who has written a tremendous paper on the necessity to repeal the FACE Act, is Senior Legal Fellow for the Edwin Meese Center for Legal and Judicial Studies here at the Heritage Foundation, and spent previously 15 years with Senator Orrin Hatch as Chief Counsel on the Senate Judiciary Committee. Andy Bath is Executive Vice President and General Counsel of the Thomas More Legal Society with more than 30 years in the pro-life movement. He has contributed to numerous nationally significant cases involving religious liberty and pro-life movements. Paul Vaughn was indicted by the government on October 3rd, 2022 for his peaceful prayer and protest outside a Memphis, Tennessee abortion clinic. 2 days later, he was arrested at gunpoint in front of his 11 children during an early morning raid of his home. His conviction for violating the FACE Act and engaging in a so-called conspiracy against rights carried a potential sentence of up to 11 years. I'd like to welcome my guest to the stage. Tom, I would like to start with you. We have a lot of questions, a lot of ground to cover, but I want to talk about, first of all, the context in which the FACE Act was actually passed. What was happening culturally that led to the purported necessity to pass the bill in the first place?
Well, you mentioned at the top, in the late 80s, early 90s, there were some tactics by pro-life activists that were more obstructive, more public. Several cities you had demonstrations involving many, many activists. And abortion advocates used that as sort of cover. They presented a bill that, in all its respects, its language, the hearings, committee reports, they all emphasized this was about bombings and arson and violence, and we have this nationwide organized campaign. But then they produced a bill that, at the end of the process, became something that made inevitable prosecutions of people like Paul and the kinds of things that Congressman Roy talked about. At every stage, it became broader, vaguer. The opportunities for its manipulation and weaponization only increased. So there were some of those tactics in the beginning that was used as, it's sort of like the magician's misdirection. Look over here at these, abortion clinic protests, and meanwhile, we're going to create this monstrosity that will be used against all of you. So that was the context, and they used it to their advantage.
At what point did crisis pregnancy centers and houses of worship get additional inclusion into the legislation itself? It sounds like that was a bit of a congressional sort of uneven but rather necessary concession to be able to make sure that this was not simply, I think, for talking point purposes, something that was going to be used against pro-lifers.
Well, the statutory language used the phrase reproductive services, which was defined fairly broadly that could cover both abortion clinics and pro-life centers. There was an attempt in the Senate led by Ted Kennedy to try to exclude the pro-life side and have it focused only on protecting abortion. But in the end, it kept that language. And my former boss, Senator Hatch, was responsible for the amendment to the original bill that extended it both from centers involving reproductive services to also houses of worship. I think, as we'll discuss, that proved to be cosmetic, because for the next 30 years, it wasn't used to protect houses of worship. I'm hopeful that the Trump administration may begin to do that, but that too was built in. I think the way it's been enforced has shown what the original strategy was, with, regardless of its coverage of pro-life centers and of churches, the vast majority of its backers were solely interested in protecting abortion.
So I want to talk a little bit about the constitutionality or purported constitutionality of the bill itself. There really was never congressional power to enact legislation like this from the beginning.
Yeah, the federal government, Congress, needs to identify a specific delegated power for every law that it passes. And in the beginning, they said there were two: the 14th Amendment right to abortion and the right to, or the power to regulate interstate commerce. Those were the two that were claimed as the basis for the FACE Act. Obviously, the Supreme Court, not the Constitution, created the right to abortion, and the Supreme Court, thankfully, in 2022, corrected that mistake. And the court said that Roe versus Wade, which created the right to abortion, had been egregiously wrong from the start, which means Congress didn't have authority in that way in 1994 any more than it does now. And within 1 year of the FACE Act's passage, the Supreme Court began reining in the power to regulate interstate commerce. And since then, it has required two things. The Congress can regulate intra-state activity, but it has to be economic activity, and that activity has to have a substantial effect on interstate commerce. Two requirements, not one. And of course, the FACE Act doesn't regulate any sort of economic activity at all. So in our view, and I want to acknowledge my co-author on our paper, Seth Lucas, who's a colleague in the Meese Legal Center here, we laid out why, on both grounds, either there wasn't authority in 1994 or development since then have completely dissolved it. Congress does not have authority to maintain the FACE Act. There's also a potential additional constitutional problem with the First Amendment. Even in the FACE Act hearings in 1993 and 94, you had moderate members, those who were, generally speaking, pro-choice, who raised the issue that, we're talking here about creating a means by which the government can force people to express views and to engage in expressive activity that the government wants them to, not because that's what they want to do, and that violates the First Amendment too. So there are additional constitutional problems.
Andy, we've talked a lot about the fact that the FACE Act itself is incredibly duplicative of conduct already prohibited under criminal law. So is it necessary in the first place? We've talked about some constitutional concerns, we've talked about its weaponization, but strictly from a law enforcement standpoint, is the FACE Act necessary?
It's not necessary at all. Everything in the FACE Act, there's no constitutional warrant for it, and it's very problematic. For Congress to intrude into what should be a state and local legal issue threatens our whole scheme of separation of powers. There's no need for this. Now, the pro-life movement, after Roe versus Wade was decided in 1973, the pro-life movement was finding its way a little bit through the 70s and the 80s. And in the 80s, when abortions were being committed at over 1 million a year, they decided we have to take some action. And so they started doing sit-ins to just shut the clinics down. And so this was civil disobedience in the style of the civil rights marchers. They would do a sit-in, they'd be arrested, cycled out of the system, come back the next day, do it again. And the numbers grew until it peaked in the early 90s. In 1991, we had the Summer of Mercy at George Tiller's late-term abortion clinic in Wichita, when hundreds would come every day, dozens would get arrested, and this went on day after day. The next year, people in Milwaukee thought we can top that, and they did public announcements, had rallies, had thousands appear at the clinics every day, hundreds arrested, and the system responded. They knew how to handle this. So what they did is the judges started putting conditions on release. So if you go back to the clinic the next day, you're going to go to jail. And if you won't agree not to reoffend, you're going to go to jail now. So this is going to stop. And then judges started ordering civil injunctions. You don't need the FACE Act's injunction in order to do this. And there was a little glitch in the system because back then the county attorney in Milwaukee, a liberal Democrat, was a pro-life Catholic. And he went down and just dismissed all the charges. And so that's not going to happen today when we have these Soros-funded prosecutors. There's a way for the system to have this. There are injunctions that are still in place today, dating back to 1992, that are more restrictive than the FACE Act. And what we got was the federal government making a federal crime to trespass on state property to do a sit-in, and that's just not right. We have to preserve our ability to engage in citizen self-government and stop this abuse of federal power.
So, Paul, you have a very interesting story. So as we talk about enforcement, why don't you share with our audience exactly what your experience has been with the enforcement of the FACE Act?
It was somewhat violent. They like to talk about violence at abortion clinics, but I can tell you violence showed up at the hands of the FBI at my front doorstep a little after 7 a.m. on October 5th, 2022. And it was interesting, the original event, the pro-life event that was in question was March of 2021. So this was 18 months after the event. I wasn't arrested there, didn't break face, didn't do anything illegal. Matter of fact, talked with the police officers and had a good rapport with them, helping them communicate with the pro-lifers. But of course, what happened between March of 21 and October of 22 was Dobbs in June of 2022 and the creation of the Reproductive Health Task Force. So that led to 4 armed agents in tactical gear showing up. 3 of my children were sent outside as we were about to take them to school. They were held by an armed FBI agent in the side yard, one of which my son is with us here today. And while they arrested me in front of my wife and the remaining children in the house, 7 of my 11 children were home that day, at gunpoint, with lethal force, and put my life at risk for not following the narrative, not accepting the narrative that the unborn babies are not worthy of protection. That's all I did that day. I prayed, I sang hymns, I talked to the police officers, and for that, Biden sent the Gestapo in with the heavy armed guards and put my life at risk in front of my children and hauled me away without the issuance of a show of identification, show of a warrant until I was in custody. My wife, my family, our pastor, my state senator, my governor, nobody in Tennessee knew where I was for 6 hours. I literally was kidnapped off my front porch and taken to an hour away to Nashville to the federal courthouse to be arraigned.
Tell me what happened during the trial, Paul.
Sure, the trial was an experience of a lifetime, and not in a good way. When you think you live in a country that is free and there's things called justice and liberty and a case, a process that is supposed to ensure those things are out there. And what we saw in the trial was a limited scope of evidence, manufactured outright lies, potential, whoever she was, one of the pro-lifers turned and testified against us and made up the story and the narrative that the prosecution wanted to hear. And then ultimately I was found guilty of FACE, not because I broke FACE, but because of this conspiracy law, this KKK Act from the 1800s that makes it a felony to conspire against violating somebody's civil rights, in this case, the supposed right of abortion. And so that takes, and I think Andy will probably talk to this, but it takes the FACE Act and goes exceedingly beyond what Congress's original intent was. And, gave me, for over 18 months, I believe it was, we had over 10 years hanging over my head of risk of being in prison as my children and my wife and everybody was waiting to find out what would happen to us.
So let's talk a little bit about the weaponization of 18 U.S.C. Section 241, which is precisely what Paul was talking about, the conspiracy against rights. That's a relatively new iteration for the enforcement of the FACE Act. Tell me exactly, Andy, where that came from and how in practice it's actually impacted pro-lifers.
This came from the Biden Department of Justice. In 2022, their reproductive rights enforcement section at the DOJ in Washington, D.C. published a paper called Face Off with Anti-Abortion Extremism, Criminal Enforcement of 18 U.S.C. 248. That's the FACE Act. And in this paper, tantamount to an admission in my mind. They had the gall to say, although criminal conspiracy offenses are usually charged under 18 U.S.C. 371, a conspiracy to commit a FACE Act offense should be charged under 18 U.S.C. 241, conspiracy against rights. So they're saying, they're admitting they're abusing the law, doing something novel. They're taking a law passed in 1870 to get the KKK, this conspiracy against rights statute that is meant to penalize people who are going hooded in the night and grabbing black people and lynching them, instead of the conspiracy statute that they would ordinarily use if they were being honest. And that conspiracy statute has a very common sense provision that says that if you're convicted of conspiring to break a law, and that law is a misdemeanor that carries a certain penalty, being convicted of conspiring to break that law can't carry a penalty any greater than if you actually succeeded in breaking the law and you were convicted of that. So this is an egregious abuse of government power. And we have layers of abuse of government power here. There was no reason for that early warning SWAT style arrest. That's an abuse of power. Paul didn't break the FACE Act. Charging him with that is an abuse of government power. And then adding this to it is another abuse of government power. Because the FACE Act, by its own term, no more than 6 months. So Congress, the people engaged in citizen self-government by sending their elected representatives to Congress. Congress says no more than 6 months. The Biden Department of Justice says, oh, we'll do this little trickery here, and we'll make it a felony worth up to 10 years. And that's just not right. We are fighting against that, and I have to say, echo what Congressman Roy said. We're very grateful to the President for the pardons. We submitted pardon applications for all of them. We got tremendous support from members of Congress. We got tremendous support from senators, and there was a public outcry that supported us in this effort. And it's only right that Paul is free to sit here today and talk with us and not sitting in a federal prison because he did violate the FACE Act.
Let's talk about some of the arguments for repeal. And we've walked through the multitude of problems with the bill itself, with enforcement, but let's sort of divide those into certain categories. Tom, let me start with you. What are, to your mind, the strongest arguments for repeal of the FACE Act?
Well, if you do have an opportunity to read our paper, we talk about three things, both how the legislation was designed, how it's been enforced, and whether it's constitutional. I think all three of those provide arguments for its repeal. I can't emphasize enough, this law was designed for Paul to be arrested and threatened with 10 years of imprisonment. From the beginning, I don't want to give Chuck Schumer too much credit, but his original FACE Act bill was the modest, moderate one. He introduced a bill directly responsive to what they said was going on. It prohibited only obstructing the entrance or exit from an abortion clinic, and it only allowed people directly impacted by those activities to sue. It became something that was unrecognizable, that allowed attorneys general to sue people for being aggrieved at what someone else was doing and all this sort of thing. It was designed to be as open-ended and as available for weaponization as possible. Our founding fathers believed that, government is the best expression of human nature, and I'm sorry, but Madison said, if men were angels, no government would be necessary, and if angels governed men, no limits on government would be necessary. You give government something like that in the service of an agenda like abortion, and this is exactly what you're going to end up with. So that kind of ideological weapon should never be in the hands of government, whether it's about abortion or anything else, and especially on an issue like abortion. And on constitutionality, if we can't have a consensus that laws that are repugnant to the Constitution are no laws at all, and should either never be passed or should be repealed or overturned. That's what our founders said. Then we have deeper problems even than I think, and I'm pretty pessimistic about such things, right? The law, Congress did not have authority to pass it. What Andy was referring to is a great example of how abortion seems to change everything. All sorts of legal principles, fundamental, rules and values, the structure and the principles on which our government was organized, all of that. Every legal doctrine imaginable somehow is up for grabs and can be sacrificed when the issue is abortion. But we should believe that Congress, they may pass laws they don't have authority to pass. And, to be fair, it's working both directions too. A law that I like shouldn't be passed if it's unconstitutional either. But a law that is clearly unconstitutional, that Congress had no authority to pass, and that was designed to be and has been used as an ideological weapon to destroy people's rights and liberties, ought to be repealed.
What, to your mind, Andy, is the strongest argument for repeal? It's hard to pick one. Obviously, we've talked about quite a number of them today, but your work specifically in this space for so long, in the pro-life movement, and this has been something, I think, about which we can all agree, in that for many of us, this is really a lifetime commitment. We don't get into the pro-life movement occasionally one day because we decide that maybe the cause of unborn life is worth protecting. Many of us were raised in the pro-life community. For my part, at 14 years old, I was trotted out in the Wisconsin State Assembly to testify on behalf of a parental notification bill for abortion. So I think we all come with very, very deep roots in the community itself. But to your mind, Andy, where is sort of the crux of the issue for repealing it?
Well, I think Tom has hit on that. It's unconstitutional and it should go. It threatens our whole notion of citizen self-government if they pass laws that are unconstitutional. Now, you might say, gee, President Trump is now committed in writing to de-weaponize government, and he's committed in writing to de-weaponize the FACE Act. Two different documents. Why should we put any priority on this now? Well, there's a bunch of good reasons. For one, President Trump is term limited, and in 4 years, the other crowd might come in and start and re-weaponize the FACE Act. A second reason is that the FACE Act, by its own terms, is enforceable by state attorneys general. So I'll give you some good reasons. Letitia James, Rob Bonta, Kwame Raoul, Keith Ellison. It goes on. There's a lot of good reasons to repeal this now while President Trump is in office and would sign a repeal bill. There's another reason. It's also enforceable by any aggrieved person. So Planned Parenthood could weaponize it. Anybody. And this bill has been weaponized. We've seen it. It hasn't done our side any good, even though by its terms it will protect pregnancy resource centers and churches. It's a weapon that we need to take away from malefactors who would misuse it and abuse government power.
Paul, you've had the most uncomfortable and up-close experience with the politicized enforcement of the FACE Act. And we talked a little bit before the event about this is really sort of the culmination of an ongoing campaign of abortion advocates to essentially censor speech that is counter to their notion of radicalized abortion up until demand. And this began in one respect. Here we are now, and now it's just simply expressive activity, quietly praying, quietly worshiping, and they found a way to weaponize it. So talk to me about your biggest concerns with why, if we do not repeal the FACE Act, it could be increasingly problematic for the movement as a whole.
Well, there's the idea of a public sentiment, a public thought, and how we as a nation consider and think about the things that we value and what we invest our time and our energy in. And the FACE Act was nothing bigger. There's lots of things the FACE Act was, but one of the things it was is the hands of government putting its hands on the scale on the abortion debate and the abortion public discussion, not as a legal debate, but as just a public consensus. And so it's a waterfall effect, if you will. If you put a legal risk of those that are out at the abortion clinic doors, that flows back to the sidewalks, it flows back to the crisis pregnancy centers, it flows all the way back to the Congress and the legislative sessions. And everybody's conversation around abortion now is limited because of this felony, this narrative that's being put on those that are the activists on the front lines. And I think we see that that is flowing over into every area of our government around these areas of unacceptable narratives to the left, to the right, whichever side you go on. We should, at anything, be able to come together as a nation and be able to determine what it is we value and what we hold. And it moved everything, Andy was telling the story about the local rescues and how effective they were being. If a community comes together and says, we don't want to kill unborn children in our community, should not a community be able to do that according to our constitutional way of life? And what this act did, and many other acts along the way, or actions, I should say, by the government, is to not allow that. We don't have that right now, so we're all forced to accept this. And the clinic we were at that day, that was one of the reasons we were at this particular clinic, is the Mount Juliet, city of Mount Juliet had voted and decided they didn't want the abortion center facility in their community, and they tried to get them out. The clinic sued, and through a big lawsuit, they ended up losing $250,000 lawsuit settlement against them, and the community that didn't want abortion was forced to have that clinic in their community.
Last question before we open up the floor to questions. Tom, as someone who spent years on the Senate Judiciary Committee, you understand that that 60-vote threshold is a tricky one. And if we are unable to achieve success in repeal of the FACE Act, are we achieving or seeing any encouraging signs from the current administration about ways that they would enforce the FACE Act properly?
Well, to be candid, there's no such thing as permanence in Washington. So even if tomorrow Congress passed a repeal bill and President Trump signed it on Monday, that's not a permanent repeal. Another Congress could reenact it and another president could sign it again. So whether it's a president rescinding his predecessor's executive orders and going back and forth like that, Congress can do that too. So let's not have any illusions that repealing the FACE Act would mean it would, in fact, always forever be gone. The truth is, as you alluded to, there's a 60-vote requirement in the Senate to end debate. The Senate has to end debate before it can vote on anything. That's a very valuable part of the Senate's legislative process in general, but it is, 60 is 60. And as you know, 47 senators recently voted to filibuster a law that would have, or a bill that would have protected babies born after a failed abortion. Well, if 47 senators are going to do that, at least 41 senators are going to filibuster any bill affecting the FACE Act, whether it's modifying it or repealing it. That doesn't mean we shouldn't try, as Andy said. I don't care how a law is enforced. If it's unconstitutional and Congress doesn't have an authority to enact it, it ought to go. That said, if it's going to be on the books, and it is, if it's going to apply to both abortion clinics, at pro-life centers, and churches, which it does, then it ought to be applied and enforced reasonably and fairly. And I think it was just on Monday, the administration indicated an interest in a California case using the FACE Act to prosecute anti-Israel attackers against a synagogue. It's exactly the way it ought to be used. If we're going to have it and it protects houses of worship, then we ought to protect houses of worship. It ought to be narrowed in its application, limited to more objective, serious cases. That's exactly what they tried to do in Congress. Both the House and the Senate, when it was going through, members introduced amendments to try to scale back some of this vague, expansive language, to keep it more confined and focused. If that's the way the Trump administration is going to enforce it, I say fantastic. Obviously, actions speak louder than words. The administration has already taken steps that no previous administration has taken. They obviously have to prove by their actions that those steps are serious and real. We'll see that unfold. But if we're going to have a law on the books like this, we ought to do what we can to limit its damage and to where it can be used for a good purpose to protect houses of worship, it ought to be.
Let me open the floor up to questions in the time that we have left for our panelists who are expert in these particular areas and the permutations. We're also going to open up questions online, and Megan will be monitoring those for our audience. Andy, do you agree with Tom's assessment that if we've got to have it, it ought to be utilized in such a way as to make sure we're protecting CPCs and we're protecting houses of worship as well? And in fact, in the entire history of FACE Act enforcement, of 211 charges, 211 prosecutions and convictions, only 205 of them, 205 out of 211 were against pro-lifers. So this is a nationwide scandal when it comes to politicized government. Is your response the same as Tom's?
Exactly the same. Now, Congress has come in and stood with us on this. They've had the director of the FBI in. They've had the attorney general in and questioned them about this uneven enforcement. This is purely viewpoint discrimination, which is unconstitutional. And you know, the FACE Act does give individuals who are aggrieved the right to sue in federal civil courts. But if you don't identify the perp, we don't have a defendant. And since the Department of Justice is so thoroughly weaponized and corrupted, they never identify the perps who commit vandalism or other kind of violence against pro-lifers, crisis pregnancy centers, and churches. And so I think I agree 100% with Tom and Sarah that if it's going to remain on the books, which I think it shouldn't, it should be fairly enforced, but I think it's got to go.
Sarah, I could add, even where Congress is concerned, it's not an all or nothing thing. Either you can pass a repeal bill or there's nothing you can do. Republicans have a majority in both houses of Congress, and most, in the House's case, the vast majority of Republicans are pro-life. They can hold hearings on this. They can pass resolutions stating it's the sense of the House, it's the sense of the Senate that the FACE Act is unconstitutional, that Congress doesn't have any authority to it. The Department of Justice can do various things, whether it's an opinion from the Office of Legal Counsel on the constitutionality of the FACE Act, or these kinds of things can all contribute to dismantling the fictional foundation for this law. You know, it took 50 years to overrule Roe versus Wade. Yeah. During those 50 years, there were so many things that groups like Andy's, state legislators, and others did along the way to chip away at and to weaken the foundation of it so that it would eventually fall. So there's a bunch of things that can be done, even if a repeal law cannot be signed by the president or might be undone in the future. There's lots of things that can be done. Pro-life members of Congress have to prove it by taking the actions, all actions that they can.
Paul, has your experience with FACE Act enforcement changed your willingness in any way to continue to do what you're doing to advocate for life?
Not at all. And that's another point I was going to make. The other way to get rid of the FACE Act is by those good and pure moral souls that I had the privilege of being with in the hallway that day in Mount Juliet, by confronting the FACE Act and saying, you know what, this law is unjust, and we're going to put it back in the courts and have the courts deal with it once and for all. And that's a risk. The odds are against them. I think even more so in the Senate, in the conviction rate in the federal courts. But that is another, another option, I suppose, out there.
Yeah. Questions for our panelists? Back here.
The FACE Act defendants challenged the validity of the law when they were prosecuted?
For me, yes, absolutely. We got acquittals and we got some convictions, and we used the convictions as vehicles to challenge the constitutionality of the FACE Act, and those were in place when the convicts got pardoned. And so we're still determined to establish in court, have the courts declare this to be unconstitutional for a lot of good reasons. But unequivocally, yes, is the answer.
Megan, we've got one online.
What do you mean by weaponization? Because isn't the law simply being enforced?
Where to start?
I have a thought. Sure. Weaponization is when when the FBI shows up at your door and there's a gun pointed at your head. That's weaponization. And when you didn't break the underlying law, when the law is used illegally, that's a concept we need to come to grips with, is all laws can be used legally or illegally. And in this case, the FACE Act is being used illegally, I would claim, and I would pass it to the lawyers to comment on that.
From the sublime to the ridiculous. It's a good question in the sense that, you know, the word weaponization is somehow more popular in the last few years. And of course, especially among lawyers, you know, 5 words mean 12 different things. However, when you have a law like this that was, and again, read the paper about how the law was developed, how it was designed. When it is designed in a way to maximize its broad use, in multiplying the ways in which it can be used illegally, unconstitutionally, to suppress ordinary expression and activity. When it's designed that way, it's designed to be a weapon. When it's driven ideologically to the point where, as the congressman said, what was it, 97% of the prosecutions have been on one side. In the known universe, there is not a chance that that happened randomly. That doesn't happen by even-handed, fair, objective application. It happens by weaponizing, using something as an ideological weapon. So I think that's the sense in which we're talking about it, and all the facts here point in that direction.
Yeah, Paul, you wanted to add something?
Just a quick comment, the document that Andy has there, where he's reading this article from the DOJ attorneys, and he said when it starts out that there are 3 advantages to using this conspiracy in this way. Well, is the DOJ looking for advantages or are they looking for justice? And I think that's a clear telling sign of the purpose of the underlying FACE Act and the application of that conspiracy was weaponization.
That's a great characterization. Andy.
When it comes to weaponization, I have this to say, additional thing to say. This has all been good commentary so far. If the FACE Act prohibits the use of force, threats of force, or physical obstruction to prevent somebody who is providing or attempting to provide or attempting to obtain reproductive health services because the person is doing that, and you arrest Mark Houck, who was standing on the corner praying, no one was around, no patients, nobody was receiving or attempting to receive. You put him through this and you do a very public SWAT-style arrest in order to send fear throughout pro-lifers all across the nation. And this guy didn't even come close to violating the FACE Act. And so when we say weaponizing, if you have the power of the government at your disposal and you can send a message nationwide that if you go to the clinics and try to save babies and offer assistance to desperate women, we are going to amass the power of the state and come down on you like a ton of bricks. So even if you've done nothing wrong, you need to live in terror if you go there, that we're going to come at early dawn and collect you up. And so if they have that power and they know that the process is the punishment, even if we get an acquittal at the end of the day, they've had the punishment. And Paul Vaughn there was no force, threats of force, physical obstruction. He didn't violate the FACE Act, yet they came down on him like a ton of bricks. And so we have to say, we're sending a message back. And we say to the pro-life movement, if they try to do to you what they did to Mark Houck and what they did to Paul Vaughn, the Thomas More Society is going to be there for you and have your back and see to it that your rights are vindicated. That's what we can do.
Deterrent effect of harsh punishments.
Other questions? Yes, right here in front.
Hello, thank you for being here and hosting this. My question is, what role do you think the government should play and what action do you think they should take, if any, to prevent unwanted pregnancies in the first place?
Wow, where to start with that one? You know, I think, first of all, the fact that most of the charitable work in the country is being done by religious nonprofits, many of whom run a lot of these crisis pregnancy centers and a lot of these resource banks for mothers who find themselves in unwanted situations. I think the opportunity to partner with faith-based organizations is huge. I think that's something that we can continue to utilize even more so under this administration. I think also, obviously, and we understand, after Obama and then again with Biden, the attempts, I think, to sort of increase access to health care also encourage these young women who find themselves in positions of sort of surprise with these unwanted pregnancies is going to play significantly in. And I think also preventing sort of unwanted pregnancies, I would think it would also include mandatory ultrasound so that a woman is fully informed of exactly what developmental stage her child is at and where that child is in their process. That would probably make sure that an individual thinks very, very strongly about what they're going to do with their pregnancy.
And I think we need to strengthen the factual understanding, the belief, and the conviction that human life is valuable. Every person in this room was a fetus. Every person in this room was an embryo. I am the same human being that I was, well, let's see, 64 years ago, right? Before I was born. It's the detachment of those things, the separation that somehow you and I before birth were a different being, a different thing than we were after. That's been, I think, part of the basis for, engaging in what we all know makes babies. And then when a baby exists, because it's something different, because it's something that's not valuable, we can dispose of it. It's addressing that I think ought to challenge the concept, the very idea of an unwanted pregnancy. Anyway, that's a thought. But I think on social media, every time I see, and there's so many of them, every time I see someone arguing that it's a parasite, just a clump of cells, blah, blah, blah. They're talking as if they themselves were a different thing before they were born. And if they believed that they were the same, I think their attitude toward killing human beings before birth would be different.
Paul?
I just would say, I've never known the government to create a baby. And so, yeah, I appreciate the question, and I say that jokingly, obviously. But I think it goes to the public thought again, our public sentiment of how we think about these things. And there's two people that are involved in creating a child, and if it's unwanted, then those two people are responsible for decisions they made. And so I don't see where we need the government in our bedrooms at all. And so that would be my position, is the government needs to get out of the way, let people in our culture be responsible for our decisions we make. And if you need help, then there are people that are moral, good people that are a part of these religious institutions that are designed for this very purpose. And of course, your own family and friends and people that love you and know you would come around in a heartbeat to help in a difficult situation as well. And that's what we find on the streets day in and day out as we're dealing with these questions.
Yeah. Time for one more question. Yeah, in the back there.
Thank you. I'll try to be quick. So you've highlighted on one hand the facial unconstitutionality of the FACE Act, and on the other talked about how, so long as the FACE Act exists, it should be consistently enforced and protect churches and pro-life pregnancy centers also. So my question is, really appreciate your thoughts on kind of the tension between those two things, especially for those of us who are litigators, right? So if I as a litigator have the wonderful privilege of representing someone, if I had the privilege of representing someone charged on the FACE Act and arguing in a full-throated way, this is unconstitutional, this law is unconstitutional on its face, it seems to me that there's at least a question to think about if I then represent a PRC to use that exact same statute to, sue somebody, right? And so my question is, what are your thoughts on that kind of tension between the unconstitutionality and the need for equal enforcement while it still exists?
Want me to take that one?
You do those cases.
Okay. When the FACE Act was signed into law in 1994, a lot of people thought it was unconstitutional, and there were a lot of court challenges, and they all failed. So a whole bunch of judges have said this thing is not unconstitutional. Of course, those all predated the Dobbs decision, which said that this 14th Amendment claim to a right to abortion is fictional. Okay, so if you're going to have judges say, yes, there is a right to abortion, and yes, this thing is constitutional, then at least apply it fairly and don't engage in another unconstitutional thing, which is viewpoint discrimination. Okay, the government can't do that either. And while we're saying, while it's on the books, enforce it fairly, don't engage in viewpoint discrimination, we're also saying this thing is unconstitutional on its face, which is where you started your question.
I don't see any tension between the two at all. Every law, to get a law declared unconstitutional and therefore nullified requires a court, ultimately the Supreme Court, to say so. That may or may not happen. Litigators know how difficult it is to put together the right case, to get the right issue before the right court, and all of that. Should Congress have taken its oath to support and defend the Constitution more seriously and said we don't have authority to enact this? Of course, but they did. And every law that's on the books, as Andy was just alluding to, should be applied and enforced objectively, fairly, so that it doesn't cause even more legal problems. So I don't see any tension between those two objectives at all. And as I said, there are other things that both the legislative and executive branches can do with regard to the FACE Act, its validity, its enforcement, its weaponization, and they ought to do those things too.
Thank you for joining us today. We're so glad that you spent a portion of your day. Please give my panelists a round of applause. This live stream will be archived at heritage.org/events for any of you who'd like to share it with friends or associates who understand, like we do, that the FACE Act needs to go. So thanks for joining us today. Have a great rest of your day.